You're watching Capitol Connection from the Illinois State Capitol.
Welcome back. We now turn to our Reporters Roundtable, and joining us this week are two new reporters who have never been on the show before. Thank you both for joining us. Mawa Iqbal from WBEZ, State House reporter here in the Capitol, and Patrick Keck, State House reporter for the State Journal-Register here in Springfield. Thank you both for coming on the show today.
Thank you.
So the reason I brought you on the show, both of you were in the Supreme Court for the Safety Act hearings, as well as myself, and it was a very interesting process. And Mawa, I'll start with you. The actual question, this was the first time we got to see the Supreme Court justices' responses, reactions to these arguments. There's been a lot of predictions and prognostications about how they would react to this, but now we officially really got to see it. And was there anything that really stood out to you from how each of the justices was responding to what the Attorney General's office and the state's attorneys were saying?
Yeah, it seemed like Chief Justice Tice had a very strict, hard line of questioning when the plaintiffs came on. So the plaintiff's attorney, Jim Rowe, was talking about, our standing, right? So it's like, what is our legal standing, meaning like, what's our interest in this case? And I feel like Justice Tice was really sort of going in on like, what is your relevance, right? So like, you are representing sheriffs, how are sheriffs involved in the bail process? And so the plaintiffs, arguing that we have this inherent responsibility to uphold the public safety, right? And to make sure that, crime doesn't go up. And so it's kind of the same rhetoric that we heard during the campaign cycle last fall, where it was like, the Safety Act would allow all these criminals to be loose on the streets. So, which of course has been debunked since then. But I just thought that line of questioning was very, very interesting.
Yeah, Patrick, it was really abrupt. We were sitting right next to each other in the courtroom, and the Attorney General's office went through their arguments, and they got some questions and some good prying into exactly what they were trying to argue. But as soon as the state's attorneys got up there, started to give their argument, Chief Justice Tice was all over it and really, really hard line questioning their motives behind this entire case. And that, how upfront it was really surprising for me. What was your reaction to hearing exactly what kind of questions she was asking them?
Yeah, I think certainly, I think it was maybe a sentence or two into State's Attorney Rowe's, discussion, and she was like, well, where's the grounds for this? I also thought Justice Holder White, I thought she was very solid. I thought, she did a good job of making sure points were fully in their context, especially on the Attorney General's office. If there's a reference to something, she seemed like she knew the whole content of it. Like, this is actually the full statement behind it. So I thought she seemed like she had done her research on this, of course. Yeah.
Patrick, there was no question that this whole thing has been politicized. The Safety Act itself has been politicized. It was the main attack for Republicans on Democrats during the election cycle, and a lot of the lower courts' positions and rulings had some political energy behind it as well. There's always the question of judge shopping in cases like this. It was seen during COVID, it was seen during the firearms lawsuits, but now we're at the high court. These are elected justices, but this is the final say-so. And after months of covering this story, what did your perspective on the arguments themselves, or your understanding of them, change as they presented them to the Supreme Court justices?
I think one thing that, I wouldn't say changed my opinion, but one thing that really stuck out, I guess, was the whole idea of separation of powers. There's a lot of discussion on, what the legislature has done dating back 60 years. And, the argument from the Attorney General's office was, this is not a separation of powers issue. If this ruling is against, goes against what we're looking for, basically they're going to be very limited in their response in terms of making public policy, and their argument is that that's the job of the legislature. So I think that's really what stuck out. On the prosecution's end, their whole thought was, well, no, the legislature is limiting what judges can do, basically because now judges would not be able to set cash bond. But again, that kind of gets into the whole, how do you define what a sufficient surety is? And I thought those two, separation of powers, your definition of sufficient surety in the 1970 state constitution. I think that's really, it's what had been listed in arguments on both sides, but I thought we got a little more into like what that actually means. Sometimes, just on the docket, it's just, how is it actually presented in the court of law, I think was interesting.
Yeah, the Attorney General's argument, Mala, was that if the Supreme Court were to rule in favor of the Attorney General's on the separation of powers argument, it would upset 60 years of pretrial laws and legislation from the legislature, and that was interesting because if you take both of these rulings, the Attorney General's argument really, and it would be true in this case, if the Supreme Court ruled in favor of the Attorney General, both on the constitutionality question and the separation of powers question, it would really seem to hamstring the legislature completely on pretrial legislation. Everything would either have to go to a referendum or would have to be within the court's power to make those changes. And that was really I don't think that became very prevalent in the initial questions. There was a lot of questioning on whether that point had any ground to begin with in the lower courts, but to really have it presented in front of the Supreme Court offers this really interesting possibility of the court really grabbing power back in this whole argument.
I would say so, yeah. I mean, like when I covered the Kankakee County court case, it didn't seem like that part, like the public policy, what is the legislature's role when it comes to enacting public policy? I feel like, at least from the defendant's side, that wasn't fleshed out as much. I think the main question was the constitutionality, right? Like that was the main argument that the plaintiffs had was, like this is available by sufficient sureties is listed on the Constitution to mean a monetary bail. Defendants came back and were like, well, this could mean not necessarily monetary bail, but something else, another pretrial condition placed on a person. And they did talk a little bit about, I think it was the plaintiffs that really hammered home the point in Kankakee that was like, this is a broad overreach of the legislature's power. But I feel like the defendants really came back. Alex Hemmer with the Attorney General's side really came back this time and was really like, no, we have, like you said, like 6 decades of precedent where like the legislature does have this power to enact laws, and they have done so for the past 60 years. I thought that was very interesting to see.
And the other interesting part of this entire case is outside of the scope of just the Safety Act itself. Obviously, quite a few new justices on the Supreme Court. It's a 7-2 majority for Democrats looking at it, but this is not going to be the last big ruling that the Supreme Court has. They're going to go in May and talk about the assault weapons ban. And talking with people who really know these cases, it seems like people don't think the assault weapons ban case has as much standing as the Safety Act, the possibilities around the Safety Act. But to see this be a real tone setter for these big political questions right off the bat of Governor Pritzker's second term, right as Democrats continue to hold this supermajority, if they're going to be working towards some of these big legislature questions, which will no doubt bring more constitutionality questions. Do you think this is a way to really gauge exactly where the Supreme Court stands and for this case in particular? I
think so. I mean, so with the assault weapons ban case, that's another question of constitutionality, right? So plaintiffs are arguing that this ban on assault weapons is violating people's right to self-defense because the argument is that assault weapons, assault rifles are in common use. And so that's the part that's being debated right now from, in that case is just what is common use and is it even unconstitutional then, right? So I feel like, like you said, we do have a 5-2 majority Democrat on the Supreme Court majority, and I feel like depending on how they rule here, that could say a lot about how they rule in these assault weapons ban cases. I mean, it's a common strategy for plaintiffs to bring suits in lower courts where they know that the judge will more likely lean in their favor. And we've seen with the assault weapons ban, lower court suits, they've been filed in downstate Effingham, White County, Macon County. These are all counties that have more Republican-leaning conservative judges. And so now if you have it in front of the high court, which, we've established is mostly Democrat, it'll be interesting to see how they rule.
All right, well, Mawa, Patrick, thank you both so much for joining us again. If you want to see their work, you can check out Mawa's work at WBEZ and Patrick's at the State Journal Register. We'll be right back, and we'll be sitting down with Representative Noreen Hammond, the Republican chief budgeteer in the House, to talk about something that hasn't really been discussed in Illinois legitimately for quite a while, and that's tax cuts. We'll be right back.